we've heard a number of different issues come up. I just want to get some clarity. We have in front of us a proposed amendment to the zoning bylaw. That's what's in front of us, right?
That's correct.
And it is a requirement in law that we have a hearing specifically on the topic of the zoning bylaw separate from other issues. That's part of just the legal process of amending the zoning bylaw, right?
That's correct. This is a statutory meeting under the Planning Act.
So this is a statutory meeting under the Planning Act. Okay, good. The second thing I wanted to ask a little bit about, one thing that just about everybody I know in the planning field will tell me is we don't zone people. And I just want to get a sense from you about why that's so important.
Through you, Madam Chair, people zoning is essentially amounts to the regulating of the user and not the use. And so if you do that, zoning can be challenged as ultra vires. In other words, it's beyond legal ability to do so, or vague or discriminatory. So we always focus all zoning and zoning changes on land use, not the user.
And I mean, let's be honest with each other for a minute. There have been instances in Canada and other jurisdictions where municipalities have tried to zone the user and not the use, and these efforts have come out of, motives that are deeply discriminatory, that are at times racist, that classist, that are about othering people. That has happened. That's why it's a very strong principle in planning law not to zone people. Am I right?
That's correct. It's been adjudicated at the Supreme Court in many famous cases. I think I'm looking at Brian, but the Bell case is one that comes to mind where, and in fact, the Planning Act has been amended specifically to direct municipalities to not pass bylaws that deal with this approach.
Yes, that's correct. As the Chief Planner has indicated, the Planning Act deals specifically with use as opposed to user. And there is a long line of cases that establish that principle.
Thanks. There have been issues that have come up about harms that are caused because of some of the shelters and other supports that we provide to people who are either precariously housed or not housed at all. That's not a zoning matter. That's a matter of whether we as a city make the appropriate investments in supporting people and making sure that services are well run. Is that correct?
I would call that the program side of the house. So that's the program delivery decisions and directions that council gives.
And going back to my original question, when we're amending a zoning bylaw in a statutory hearing, that's a very specific legal thing. It's not a program discussion.
What's in front of you are recommendations to amend the zoning bylaw. It may incidentally raise companion issues on the program side, but what's in front of you is the zoning bylaw amendment.
Thanks very